Senator Kennedy.
Professor, you're on leave from the faculty at Virginia Law, are you not?
I am, Senator.
One of your colleagues, Professor Paul Stephen, tells me you are a rock star.
That is very kind of him to say that, Senator. Professor Stephen is a wonderful person.
I went to law school with him. He may be the smartest guy I've ever met. He deserves to be on the federal bench, frankly. I've been listening to you carefully. You don't sound to me like you're much of a politician. I like that. I'm going to ask you a couple of questions. I want to stipulate up front, Professor, you're going to follow precedent. And I know you've been coached. I'm not blaming the Biden White House. The Trump White House did it to, coach all of our nominees to just say, we're going to follow precedent. I think you'll follow precedent anyway, but I'm not going to ask you to tell me how you decide a case. That would be unethical. Might be illegal, but it'd be unethical. But I do want to know how you think. Let's take a new right. I'm not going to try to talk to you about the relationship between a fundamental right and a suspect classification, because you'll beat me on that one. But we both know that they both used to create new rights. Let's take wealth as a suspect classification. Do you think heightening the scrutiny of wealth as a socioeconomic policy is a decision for the voters through their legislative body or the courts?
Senator Kennedy, I believe the Supreme Court has already confronted the question of whether wealth is a suspect classification.
I know.
And that they concluded...
Rodriguez, but they could, once again, I'm not talking about, I know they said no, but I'm just asking you to put your law professor hat on.
Well, so I guess, Senator Kennedy, I think that the Supreme Court, in deciding Rodriguez, has essentially said that it is a matter for the legislature, not a matter for the courts. And if I were confirmed as a lower court judge, I would follow that guidance from the Supreme Court.
Okay. We know, you've probably taught it, we know that the right to use contraceptives is a penumbra of the, you correct me if I'm wrong, First, Third, Fourth, Fifth Amendments to the Constitution. Now, you don't find the words right to use contraceptives in the Constitution. And I personally think people ought to have the right to use a contraceptive, by the way. But we know that right was found as a penumbra of those amendments in Griswold v. Connecticut. But we can't see it in the Constitution. Is that a pretty fair statement?
Senator Kennedy, I would agree that the word contraception is not in the Constitution. And like you, my understanding is that the Supreme Court decision that recognizes that right is Griswold versus Connecticut.
Welcome back to the channel. Today, we dive into a fascinating Senate Judiciary Committee exchange featuring Senator John Kennedy. Known for his sharp questioning style, Senator Kennedy engages with a judicial nominee in a conversation that is as witty as it is thought-provoking. From probing questions on constitutional interpretation to his views on judicial philosophy, this exchange captures the essence of how lawmakers approach nominees for the federal bench. Let's break it down. Senator Kennedy begins with a touch of charm. He acknowledges the nominee's reputation, even quoting a colleague who called the professor a rock star. But Kennedy quickly makes it clear he's not interested in politics. He wants to test intellect, honesty, and understanding of the judicial role. The senator pivots into constitutional territory, asking whether wealth should ever be considered a suspect classification. he challenges the nominee to think beyond precedent, while still grounding the discussion in Rodriguez versus San Antonio Independent School District, a landmark case where the court ruled wealth was not a protected class under equal protection. The nominee stays measured, affirming that the court has left such questions to the legislature, not the judiciary. Kennedy then moves to a more philosophical line of questioning the concept of penumbras in constitutional law. Referring to Griswold versus Connecticut, he highlights how the court found the right to contraception in the penumbras of multiple amendments. His question is simple yet profound. Are there other unseen rights hidden in the Constitution? The nominee carefully responds, stressing that Griswold is the only case where the court explicitly used that term, but
Yes.
Okay. Are there other penumbras that we can't see?
Senator Kennedy, I'm not aware of any Supreme Court decision other than Griswold that used the specific word penumbra.
Do you think there are other penumbras out there, lurking out there, that we can't see?
Senator Kennedy, I'm not sure that I think there are other penumbras out there that we can't see because, as I think I've said, I think the only time the Supreme Court has ever used that specific word is in Griswold versus Connecticut. The Supreme Court has, for at least 130 years, concluded that the Constitution protects certain rights, such as the right to marriage, the right to travel, the right to raise children, that are not expressly set out in the text of the Constitution.
Professor, I don't really care about your politics. I care about your intellect, which is pretty well established. I care about your analytical abilities. I care about your integrity. And I care about your understanding of the role of the judiciary. And some of the nominees that have appeared before us, I believe, see their role as a federal judge to try to rewrite the Constitution and or our statutes every other Thursday to advance a social agenda that they can't get by the voters through their elected representatives. And I don't agree with that. I don't get the impression that you're like that. I'll give you the last word.
Well, thank you for that, Senator Kennedy. I think the role of a judge is very important, but I think it is a limited one. I think it is I do not think it, I think it is the role, the judge has the important role to apply the law to the facts before him or her in the cases that come before them.
Thank you, Mr. Chairman.
Yet respectful style, balancing tough questions with an appreciation for intellect and integrity. It also highlights the delicate line judicial nominees must walk, showing depth of thought without overstepping into personal or political territory. If you found this breakdown insightful, don't forget to hit that like button, subscribe for more political analysis, and share your thoughts in the comments. Do you think judges should have room to interpret beyond the text, or should they strictly adhere to what's written?